on remand or charged at Stock Farm, that he should remain there for his own safety, his own personal safety. So it's difficult.
And if you recall the sections that Mr. Bruni read out earlier, section 7.2d, the Bail Act does cover that. That's what it says, that the defendant should be kept in custody for his own protection or for the protection of the community. So it is something that is in fact considered when the issue of bail arises.
Yeah. So we have a caller on the line. Let's just take that call. Good evening. Hello, good evening.
I just want to ask a question.
Yes, please.
I heard one of the lawyers say that sometimes you have a person on remand 6-7 years, and sometimes when they go to court, they're found not guilty. But what I want to ask is, why is a person kept so long in the prison? Who is this? I'm just asking, who is responsible for that? I mean, why is it that they're kept there so long? Thank you. What is the role of the DPP in situations like that, where you have a person there languishing in prison for so long and no trial is taking place? Thank you.
Thank you so much.
Well,
Yes.
there are a variety of reasons why that may happen. And some of it is because they are systematic, in that we have what we generally call backlog. There are a lot of cases, right? There are a lot of old procedures that need not be, well, they are antiques, right? They are outdated, and we are asked to still follow some of those procedures, which really slows down the system. The issue of that is not really just having a new magistrate, having another judge, having extra magistrates. It has happened over and over, and there's still backlog. It means that you have to make changes to your system. The system that we have driving the criminal process, right? It in itself, it does not anticipate how crimes and how systems are committed in the 21st century. Some of them are based on 16th and 17th century laws. The Magistrates Code of Procedure, for example, it's an 1891 Act. The Evidence Act is an 1864 Act. Right? This legislation did not contemplate, right? And I'm telling you that as a practitioner.
Right.
Because when I came onto the bench as a magistrate, I didn't come to be a magistrate of adjournment or a court of adjournment. And that was the first thing I said, because the first day I came, I got a list of 70-something matters. The second day I got a list of 17 matters. No human magistrate can do 72 matters in a day. And of course we have a system of call over, so you have to call over all those matters before you start your list. And then you go to do the remands. So by the time you start your list at 2:30 p.m., well, that's what I used to do, not taking lunch. How many matters could you do? It's not like you go into a bank and tell her going to cash you some money.
Right.
It's hearing evidence that have to be written and has to be assessed. So there are a lot of factors. It's not a easy thing. It is not just the operator, yes. So we need to work on that. It is really affecting the rule of law in Dominica. We have not been able to relieve backlog. In fact, we have not had a comprehensive system to deal with backlog. And if we did, we would have found out some of those things and make trials less long.
Yes, remedy.
I don't think any individual judge or magistrate, you may have heard, I don't know, this is the problem in England now, right? That they have so many cases. Cases are being adjourned to 2029 and all. It is extreme. It's a huge failure that they cannot deal with the backlog. You cannot You must do something about it. And of course, you must inform the public about it, because the public will think things that they don't think. They will think that you're getting paid and you're doing no work. But if I have a difficult case, let's say a domestic violence or case of a child, it may take the entire morning or into the afternoon.
Right.
What have I done for the day? I didn't even complete that case because there was so much evidence. So there are many factors that contribute to that high level.
But here's something that's always troubled me. It's almost archaic that magistrates write out the evidence. They use their hands to write out the evidence, and those evidence are kept in books and whatever, and then they're typed up.
That's what happened to me.
Yes.
I can stretch my
Then
finger
they-
out.
Then it's typed up as it's evidence is typed up into depositions, that kind of thing. But here's the thing: if we brought stenographers into the magistrates' court, that would speed up the process for preliminary inquiries. So I think two things: we need a spurge of paper committal situations, okay, which would speed up the process of getting things to the High Court. Then you need magistrates to stop writing things by hand and have stenographers in the magistrates' court, which would again speed up the process, because it can't be in the public interest for somebody to be waiting 5-6 years for trial.
I totally agree. We have a caller.
Right.
Good evening.
Mm.
Hello, good evening.
Yes, good evening.
Good evening.
Yes, good evening to the guest.
Yes.
I have a question. When someone absconds bail, especially for a capital offense like murder, what happens to the shorty in terms of the security that was given up for that was secured for that person's bail? Now, the second question I have to it is, what is there, if anything, in place in terms of getting that person from where they are, if we have extradition treaties with that country where that person is? Because at the end of the day, I am assuming that the country forfeits whatever security you pose. What happens to the suffering family, the person who lost their life, the family? Any effort is being made or any laws in place to get that person extradited from where they are to come out and face their offense? So to me, it's like two offenses were happening committed there now. You, the shorty, you failed. That is an offense already, so we forfeit whatever you have. But the offense that was committed, the murder, it still exists against the state and against an individual. So I just would like a little more elaboration on that aspect of bail, please.
In relation
Thank
to
you.
the first question, if I can take that question, is that basically a shorty is not really asked to pay a sum. The bail is given in a particular sum, but when the accused absconds and he doesn't come back, then an inquiry will be held and the shorty may be asked to pay the sum or part of it, depending on the circumstances of how the accused left. And when that money is paid, naturally it goes into the consolidated fund. It doesn't go to the court to assist us with anything, but it goes to the consolidated funds and it helps the public generally. All right. In terms of extradition, yes, there are extradition treaties with some countries like the U.S. However, extradition proceedings are very laborious and very long, and they are sometimes successful and often not successful. You may get a red notice and ask for a defendant to be cited in another country. You may reach that stage, but the extradition itself, it's a bit cumbersome. And so we don't do many extraditions, although some has been attempted.
I don't think Mr. Bruni.
But it's a shame. I agree. It's a shame that we.
Oh no! I was saying I thought you were done. I'm so sorry.
That's all right. That's all right.
Because I just saw someone making making a statement and probably asking a question with relation to something we touched on briefly earlier, the Lera case. Now I'm not sure how much about that we can actually speak. But someone is saying this case is of great interest to the public, and of course people wish to better understand why someone accused of such a gruesome crime has been granted bail. How does the public discussion on the bail granted and the constant discussion on various platforms risk a miscarriage of justice eventually, and why? So basically what I'm saying. And then if you could just tie in here also what we...
The
public interest,
yes.
yes.
I wanted to say a little
because when you talk
on
about public interest, is it how people feel, is it sentiments or what exactly?
Well, it's not...
Yeah.
Basically, it's not...
It's not.
Defined that way.
But Mr.
Basically, in determining whether to grant bail, the court will consider first the right of the accused person to liberty, which will be counterbalanced against the public interest, right? And the public interest really is protection of the community, right? The community being concerned that that a serious offense has occurred, and that the defendant will flee, and so the public has a right to be concerned, and the court will take every factor into consideration. However, there are other factors it must take into consideration, because whilst one says that, if the evidence, and I think Mr. Bruni was alluding to it, if the evidence before the court, and it's a bail, so it's just a prima facie evidence, I would say, if the evidence is so weak, it already says that there is quite likely, right, be an acquittal, or that the matter wouldn't go on. And because the public is concerned, which they should be, it does not mean that on that ground alone that the accused should be kept in custody, because you have to counterbalance both the public interest and the accused's right to liberty.
Mr. Bruni, you want to add anything?
Just to add on what Ms. Baptist said, the whole issue of pretrial publicity is one that society need to be concerned about, because what we ought to remember in criminal cases, the judges of fact are the jury.
The jury.
And if there is a lot of pretrial publicity prior to trial, it is more than likely that persons who will be sitting on that jury will also be influenced on what they would have heard before, and all of these things. So when they're sitting in trial, are they really judging based on the fact that is presented before the court, or all of the discussions and the topics and the emotions and what they would have heard in society prior to actually sitting on a jury? So it is a very sensitive area, and I believe one that person should really tread cautiously.
However, though,
We can't prevent.
Cautiously.
Yeah, but
The society we live in now. Yes, Mr. Bruni.
But personally, I think the most important aspect of bail or not to grant bail is the strength of the evidence. Because I just believe that our system of justice speaks to innocence. You're only pronounced guilty by the jury at the end of a very long process.
Right.
If innocence is what our Constitution speaks about, what we speak about, innocence until proven guilty, I think there has to be a microscopic view of the evidence that has caused the charge. Because remember, under our system of justice, suspicion is one thing, but to charge there has to be serious evidence.
Okay.
Right.
We have a caller. One second. Good
Hello,
evening.
good evening. I have a
Yes.
final question.
Yes, please.
Our cases prioritized. For example, if you have 4 murder cases, you have 3 rape cases. I'm just giving a bogus figure. You have 2 cases obstruction of the police in doing their duties. I'm just asking, which cases, to get the cases out, out of your way, how would you prioritize? Wouldn't you take the, I'm just asking, wouldn't you take the obstruction, first, and probably then the rape and then the murder? I'm just asking, because you have obstruction, and you have a lot of cases. To me, I'm not a lawyer. I am just talking. To me, I would take the obstruction first, because to me, that's a case probably that would go quickly. Say you obstruct the policemen in the performance of their duties. Thank you.
Thank you so much for your question.
Well, I would say from my experience that there has been no, how would I put it, scientific analysis of that, and there has been no method as to how you deal with those matters. You see, we deal with 3 branches. The branch that investigate the matter, the branch that prosecutes the matter, try the matter. Now, if a matter occurred in January and the investigating officer is prompt, and the investigating officer can find all the witnesses, none of them going to Guadeloupe, none of them trying to avoid being a witness on the offense, and he can't find them, etc., etc., then the matter will be ready quicker. So it will come to the DPP's desk quicker. Now, where it is a serious offense and there are a large number of witnesses or many witnesses or some little complications in the witnesses, you can't find the pathologist. You have to send the testing, the forensics to Jamaica or the lab in Barbados, or depends on what it is in the United States. It's not going to come quicker. Whilst it is a serious offense, it's not going to happen quicker because there's more investigation to do.
Yep.
Now, also, if you have a lazy investigator, sorry, investigators, it's not personal, then if he is an investigator, but he's also have some other job in the police, right? So he has to leave his files when he's called out to do all kinds of things. Then his file's not going to get done. I know in some of our sister jurisdictions, if you're in the investigative unit, if you're in the prosecution unit, you're not called upon to do anything but that. So sometimes they have the file for a long time, and when you call up, you're hearing this and that. Then I haven't been at my desk for so long. I'm doing. So there are issues. We don't have a proper division of labor, and how we do it, it's all a mess.
Right.
So with that system, it's very hard to see.
But the system could be cured.
Of course, it could be cured.
If you were to take one of our magistrates' court and put our most experienced magistrate there and deal only with serious crimes. Because many times I've been in magistrates' court doing a murder PI, for example, and the magistrate has to shut me off to take summary matters. The lady was speaking about obstruction matters, for example. So the magistrate has to close down for time considerations a murder case and adjourn it for 3 or 4 months in order to deal with other matters on her list. I think we need to have specialist courts first, because serious crime is becoming more prevalent.
Right.
And we do have our young men sitting in prisons for 5-6 years waiting for their preliminary inquiries to be finished.
Yeah.
And I think these offences need to be prioritised, especially if we're going to be denying bail. Because remember, the public is in uproar. A murder, we don't want him to have bail. If you don't want him to have bail, in the public interest, you have to speed up the trial.
Right.
And the way to do that would be to have specialist magistrates handling these serious offences.
Well,
I agree with that. I agree that because in sister jurisdictions, it's a long time now. Some of them have put in serious crimes court. They have a bail court. Somebody just deals with the bail. So in between your trial or before your trial, you hearing a bail application, but the bail application took a few hours. So we have not done that, and that is true that you can have it can be dealt with better if you have that.
Yeah, absolutely, I agree. So while we're on this topic, how do we deal, differently with juveniles in that same case? Bail, the juveniles, adults. Is it the same way that we treat them when we talk about remand and all of that?
Not necessarily. We usually do
I
not.
saw Mr. Bruni open his eyes like.
No. It's just that we still don't have a juvenile court.
Yes.
Okay, and it has to be of major concern. Now, I sympathize with anybody who's been impacted by a murder. Okay, but realistically, all the emotion in the world isn't going to right the wrongs of a poor investigation. So I think people need to start looking at the administration of justice. They need to start looking at the police force, for example, and asking questions about things like promotion, for example. Why? Because if we don't have the right people in the right positions, justice will never be dispensed. So, and this is kind of difficult, but take the constituency of Soufriere. There's a lot of controversy about this Lera situation. But if those people would ask themselves, what is the standard of proof that has been used to charge Lera? That's all they need to ask themselves. And then do an investigation of, is there any direct evidence? What is the nature of the circumstantial evidence? What is the state of the forensics? You might find, and this is going to sound crazy, you might find that it's not what you know, it's what you can't prove.
Right.
Okay? And the whole issue of bail is tied up in those kind of issues, because people being charged, and we probably realize the evidence isn't sufficient to warrant a charge, but there's a satisfaction of the public interest in a charge. And a lot of the time, people are not so much concerned about what happens 5-6 years down the road. They're interested in what happens now to pacify and satisfy. So the issue of bail, its tentacles are far-reaching, and there's so many other side issues that need to be addressed, and the education of the public too.
Right.
Yeah.
I agree. The public looks at it from the point of view, but not with any depth of understanding of what the system is. So I sympathize with them.
Right.
Right? It's not their fault. That is how they see it. As a matter of fact, if some of the public would think back, many some years ago, the death penalty was determined to be unconstitutional. So basically, they're not even looking at a death penalty in those matters. The Privy Council has said that it could only be applied in the rarest of the rare or the worst of the worst, but we don't even know what that is. So most people accused of murder is not going to face the death penalty. And in fact, there are different categories of murder. They are the ones which are more serious. They are the ones that have a fair enough evidence of self-defense.
Right.
So there are different categories of murder. I'm not saying the case that people are talking about have any of that,
Right.
but I'm just saying that, talking about it in a general manner.
Okay, we have a caller on the line. 1 second. Good evening.
Good evening. Good evening to the panel.
Good
I must
evening.
say it's a great topic that you have this evening.
Thank you.
And just on a point, it's 2 points I want to make. One, in reference to what the gentleman was speaking of, in reference to most of the investigation and starting at the police department, because before it gets into the court system, it has to already have gone through certain investigations coming from the police. And if they have not done a thorough job, when it gets into the court system, the court can only go by what has been produced. They cannot create something that, if the evidence that was supposed to be brought in to the judge on the case and it was not brought in, well, a judge can't make a decision based on lack of evidence, that was brought before a case. And another point was, and I thank you for bringing up in reference to the juvenile, cases, like why is there not a juvenile court, and everything is just wrapped around one thing, one system, and then you have juveniles with adults in the prison system. And another thing is like, why is there not a stenographer in the magistrate court that in 2024, a magistrate is still taking hand notes, in 2024. That is so third world right now. Well, thank you very much for listening, and it's great information for the public.
Thank you so much for calling. Thank you for your contribution.
In relation to some of the, I can speak for myself. I think some of the questions are beyond my pay grade. However, in relation to what the caller said as it relates to the process, I think this is something that the public sometimes do not pay enough attention of. As was explained earlier, when a crime is committed, the investigative stage is meant to go first. So you investigate, and as Mr. Bruni said, if there is enough, even if you have a suspicion, when you find that there is enough reasons to bring the charge, you bring the charge.
Right.
In all honesty, what we see sometimes happening, there is not enough evidence to bring the charge. So you have officers, a person is charged and brought before the court, and then they're scrambling for evidence. And as
you said, you do cry, but are you prosecutor or
defense?
Defense.
Yes.
Okay.
So this is one of the issues that we have, and the public, as Mr. Bruni said, has to pay more attention to these sort of things. Now, there are different types of crimes. Some may be more sophisticated, and the questions that we have to ask is the police force really equipped to deal with some of the more sophisticated crimes that are committed?
Yeah.
When it's not your family member, it's easy to say, oh, the police charged this person, so they are guilty.
Right.
Would you feel the same if it's your family member and that person is brought before the court, and maybe you may be saying that that's not really the personality of that person, or that person was probably in another place or whatever, or just because the police is interested in bringing a charge was brought.
Right.
Now, the other thing, when a person is in custody, the police has 72 hours to bring the charge. But there is nothing saying that if an offense was committed, the police couldn't take 2 months to watch, observe, gather the evidence before they even arrest a person,
Right.
and before a charge is brought. So these are some of the issues that we have, and I think that the public probably need to pay more attention in relation to some of these matters. Is it a case of sometimes our police move too fast,
Too swiftly.
that they did not gather enough evidence? So when the matters are brought before the court, that we know that there is a solid file that is going to present, because in all honesty, the magistrate court can only deal with what is brought before them. Likewise, the high court, you can only deal with what is brought before you.
We have another caller on the line. That might be our last call for the evening. It's almost 9 o'clock. Good evening.
Yes, good evening again.
Yes.
Your panelists, I would like to know what is their take on certain sentences, and I will specify, for example, firearm offenses. I've noticed that for the past cases of firearm possession, etc., a fine is given.
But we're dealing with bail though tonight.
And so,
sorry to distract. We're dealing with bail tonight. That's our specific topic.
It comes well, that's what I'm coming to with the bail about the firearm. Because the mindset that a lot of the people out there have is, I must get bail, I don't worry, and that to me that's an encouragement, because you catch me for firearm and ammunition, bam bam, I get bail, I outside. So I would like to know what is your take on it in terms of
the fines.
Maybe not fine, restricting bail. For example, people say that is draconian. But to me, like Miss Baptist was saying, there are terms and conditions to be considered in terms of considering a bail application. But I would like to know what is your take on if there was an idea that certain things do not even come from an application, is no.
Okay.
What is your take on that?
Thank you for your question.
What is my quick answer on that is that most people charged with firearm offenses in Dominica is charged under this section for having a firearm which is not licensed. So in of itself, this is just an offense for not licensing the firearm. And so the penalty couldn't be extra high. You would have to have some other kind of offense. And there are a lot of other offenses under the Firearm Act. Whether or not they can be brought or will be brought is a question, because some of those offenses you need firearm experts, right, who can come to give evidence. And most of the time they are abroad, they are out of the jurisdiction. And if you use certain countries like, say, Barbados, their firearm expert probably serving the other small islands, or they probably call them because they have been very experienced. So sometimes it's difficult to get them to come early for a trial. But basically most of the offenses, most of the charges under the Firearm Act is under this section that deals with having in your possession a firearm which is not licensed. So that's just a non-license. So the penalty would not be very high.
And just to add on what Ms. Baptist said, the caller mentioned the sentence and he also mentioned bail. Firearm offenses, as Ms. Baptist said, when most persons are charged under being in possession with a firearm without a valid license. And it's an either way offense. So most times when it comes before the magistrate puts the election, whether you want to be tried in the magistrate court or in the high court. Majority of the persons may choose to be tried in the
That's the Bail Act.
And the issue of bail only arises if that person would plead not guilty to that charge. So once that person pleads not guilty, then the issue of bail arises. If that person pleads guilty, then we go to the whole thing of sentencing. You do your mitigation and then sentencing. In relation to bail, as it relates to firearm, again, the magistrate is going to look at a number of factors if that person would plead not guilty. Where was the firearm found? What are the circumstances? How the firearm appear? You know, a number of things. Is that person a first-time offender? And a number of things in relation to, you know, that whole application that is brought before the court. So there are a number of factors that go into play. Likewise, when we get to the whole thing of sentencing, the magistrate also would take a number of things. Is that person a first-time offender? Has that, you know, a number of things that are taken into consideration. And I mean, somebody who is in defense, I think it goes both ways. I've had person who has been sentenced to prison for firearm and those who get a fine. So I don't think it is fair to say that everybody gets a fine.
Yeah. We have a call on the line. I said it was the last one, the one before, but good evening, caller.
Good evening. Is it an open line you have?
If it's an open line, no, we're talking about bail tonight. You're our last caller if you have a question in that regard.
No, what I wanted to find out is that someone is charged, right? And they have not appeared to answer the call. Now, they would be charged for not appearing. Now, if the magistrate now is unable to attend court, is like there's no premium for the magistrate or the judge.
Yes, what?
Also, you're saying that you can be penalized for not appearing, but there's no penalization for the magistrate? Is that what you're asking?
That's what I'm saying.
Okay, thank you for your question.
I would just answer that, magistrates get sick sometimes, and magistrate has to go to the hospital sometimes.
Oh my goodness, it's 9:05, and we've barely scratched the surface. There are some things that we have not touched yet. We didn't even speak
What
about
happens after bail is granted.
Yes, we didn't speak about some of the conditions. Also, bail. I know we know a lot about it, surrendering your passport and all of those things, but we barely touched those things. But we could probably take another 5 minutes to brush over a few things and to of course wrap up. Mr. Bruni?
Yes, it's I just want to be very careful, okay? But look, I always come back to the evidence that has been used to charge that has affected the right to bail and that kind of thing. And I really think when I go back to 1999, I did my first murder case in 1999 with the Shabba murder case at Mont Daniel. And I remember exactly how the procedure was and the quality of the police officers I was dealing with. In 1999, you had Duke Alfred and these people in the police force. These were, I call them super cops. And I just wonder about the way things have moved on, because in the Shabba case, they did, DNA was used, forensic evidence was used, and they brought people in from New York. I did a murder case, Point Michel murder case, maybe 9 years ago. This time they brought them in from Miami. Why haven't we got a forensic lab here that can take care of those things? And I think that the quality of justice is dependent on the investment made in the police force. And I would just say that all the people who have concerns about, for example, Lera getting bail, should really be speaking to their representatives about the quality of justice that is being offered and the resources being ploughed into the police force that would enable justice to be done and to enable that the evidence that we have against Lera, for example, is top-notch. And in 3 years we won't go to court for this murder case and be shocked that there's no eyewitness, or be shocked that the DNA evidence doesn't incriminate him to the scene of the crime. So I think these are the things we need to worry ourselves about. And I don't think necessarily we may not be, because you listen to the policymakers, and when they're talking, you're not hearing anything about the improvement of the police force. For example, a quick response unit. This is off the bat. I'm going off the bat now. If somebody was burglaring your house in Canefield and you called the police station and asked and told them there's a burglary going on, how long do you think it will take the police to get to Canefield? These little things are the things we need to be concerning ourselves about, which in the larger scheme of things will affect the whole justice system. Little things. But anyway.
Thank you.
I agree with Mr. Bruni of what he said, because I was DPP and I don't even want to tell you some of the mishaps we had because of the nature of the investigation. And I know that many times it was not the fault of the police officer. He just didn't have what it takes. He just didn't know. He wasn't trained. He tried his best. So it's not always that they're lackadaisical. There are times. Yeah. But really, there are certain things that is required. Now, I heard many people speak about seriousness of the offense. All right. In relation to bail, there was a line of cases in which the seriousness of the offense and the severity of the penalty was the basis for not granting bail. However, those cases were overturned by the Privy Council, who they observed that the right to liberty was an important constitutional right, and therefore the courts don't only look at the seriousness of the offense and the severity of the penalty, but the whole issue of his constitutional right to liberty. The court must consider that and all other relevant factors, the nature of the evidence, right, and which I know the public don't know, They haven't read the judgment or anything,
Right.
so they have not recognized that. They are only looking at the nature of the evidence. And that is why I spoke about murder. Murder is not as before. Under the common law, you charge with murder, you would never see bail. Right? That is not the case. In most murders, you are going to get bail. I'm not saying in all, but you're going to get bail. Murder does not even carry, right? Death by hanging. Some other offense does, but that particular offense does not carry it anymore.
Thank you so much, Ms. Baptiste.
And in closing, I also noticed that a number of persons had spoken of the whole issue of public interest and,
Yes.
and whether, and stating that it could mean anything. And is in a recent judgment, Justice Williams attempted to, state what was public interest. And he stated that public interest is not public curiosity. It requires the consideration to be given to the length of time before a trial is likely to take place, given the conduct of the defendant, the failure to meet deadlines and related factors, its difficulty, and concluded when the trial is likely to take place, whether there is any risk of interference with witnesses, is there a risk of the accused offending while on bail, is there a possibility of prejudice to the preparation of the defense. And these are basically some of the things that he mentioned. So as we said, public interest can mean a number of things. It's a very wide area, and every case will be taken as on a case-by-case basis when the magistrate or the judge is actually weighing the evidence or the issue of public interest. And in closing, I would just like to say in relation to the whole issue of bail, what we need to remember is bail granted or not is not a point of whether the person is guilty or innocent. It's an application that is afforded to any accused who is charged, and an application is brought before the court. It is something that is argued. When a bail application is made, there is always the defense and the prosecution who would bring arguments before, and the discretion is up to the magistrate or the judge, who then determines based on what is brought before him if he finds that there is enough reason to grant or deny bail.
Right. Thank you so much. I don't see how much better we could have closed the discussion tonight, although I feel like the topic is not completely exhausted. So hopefully we'll get another opportunity to, come and have the discussion again. But I really want to thank our listeners on DBS Radio and those who stayed with us on Facebook. And there are so many comments and questions that we were not able to get through. But we are seeing your comments, your questions, and of course, we will respond to them in due time. So we really want to thank you so much for your participation and for chiming in from New York and, from all across Dominica and, several places I saw persons chiming in. So I really want to thank our our listening public for staying tuned with us for the hour and 10 minutes that we stayed on. Again, this has been another Legally Speaking on DBS Radio. Join us again in 2 Mondays for another interesting topic from the Dominica Bar Association. Have a good night.
In honor of the late Mikey Bruni, the Dominica Bar Association presents Legally Speaking, hosted by attorneys at law. A call-in program aired every other Monday night from 8 to 9 p.m. Listen in live and call in with your questions, or listen on Facebook as the Dominica Bar Association leads compelling discussions on laws that affect our lives, our rights, and our obligations as Dominicans. Legally Speaking.
Turning on the radio. Turning up the radio. Turning up the radio. Turning up the radio. I'm pretty sure you knew what I'd done something like this, yes? In your honor. Rest in peace, Daddy. Make it to the mic.